Imagine for a second that a massive industrial disaster strikes a densely populated city, releasing a deadly cloud of toxic gas. Who bears the ultimate responsibility for that? And, maybe more importantly, who actually pays for the damage? Well, today, we're going to dive right into exactly that.
To really wrap our heads around the gravity of this question, we kind of have to rewind to a completely terrifying sequence of events. So, in December 1984, India suffered the Bhopal gas tragedy. It was this catastrophic leak from a pesticide plant that left thousands dead and over 100,000 injured. The entire nation was understandably in shock. But then, exactly 1 year later on December 4th, 1985, panic struck all over again. This time, it was in the nation's capital, Delhi. Oleum gas burst from a factory tank right into a crowded neighborhood. And honestly, just as the panic began to settle down, 2 days later, on December 6th, a second gas leak struck the exact same facility. The nightmare was literally repeating itself.
Welcome to this explainer. Today, we're unpacking the oleum gas leak case, which is formerly known as MC Metha versus Union of India. This right here is the landmark legal showdown that completely revolutionized environmental law and corporate accountability in India. We're going to see exactly how a horrifying crisis catalyzed a legal rebellion, one that forever changed the way the justice system handles hazardous industries.
So here is our roadmap to absolute accountability for today. We'll start with the Delhi gas crisis, take a look at the outdated British law that stood in the way, explore a supreme legal breakthrough, compare strict versus absolute liability, and finally, check out the polluter's pays legacy. Let's get into it. Starting off with Section 1, the Delhi gas crisis, and the absolute panic that gripped the capital. Okay, picture this. You have the Shriram Foods and Fertilizers factory sitting right in the middle of a densely populated area of Kirtanagar and Delhi. We are talking about 200,000 everyday citizens living directly in the crosshairs of a facility making highly hazardous chemicals, things like caustic chlorine, sulfuric acid, and oleum gas. The human stakes were unimaginably high here. I mean, these dangerously volatile industrial chemicals were practically sharing a fence with thousands of families.
Then, on December 4th, the whole thing escalated into an urgent crisis. The structure supporting a massive tank of oleum gas just collapsed. The tank burst and it released this massive toxic cloud into the air. The fumes were so incredibly potent that an advocate practicing at the nearby Tisazari courts actually died from inhaling them. Widespread panic and injuries just ripped through the community, and shockingly, before people could even catch their breath, a second minor leak escaped from faulty pipe joints just 2 days later. The immediate life-or-death stakes were so high that the Delhi magistrate ordered an urgent total shutdown of the manufacturing and processing of these hazardous chemicals.
But getting the factory shut down was really only step one. When victims actually sought justice, they ran into a massive legal roadblock, which brings us to the outdated British law.
So up until this point in time, the Indian legal system relied on this principle called strict liability. Now, this rule was established in England all the way back in 1868 in a famous case called Rylands versus Fletcher. It basically said, hey, if you bring something dangerous onto your land for a non-natural use and it escapes, you're liable for the damage. But here's the huge problem. This was literally a horse and buggy era law. It was created right at the dawn of the Industrial Revolution. So applying it to massive, modern, multi-million-dollar chemical industries, yeah, it was entirely ill-equipped.
And why was it so ill-equipped? Well, because of what I like to call the escape clauses. Strict liability was just riddled with exceptions. If a factory could prove the leak was an act of God, or maybe the fault of a third party, or even if they had statutory authority, they could completely dodge financial responsibility. Seriously, it was ridiculously easy for powerful mecha corporations to use these legal loopholes to escape blame, which basically left the victims with absolutely nothing.
Obviously, something had to change. And that brings us to a supreme legal breakthrough and the catalyst for a brand new no excuses rule. Enter environmental activist and lawyer MC Metha. He looked at the justice system, realized it had a fatal flaw, and took action. He filed a public interest litigation, a PIL, directly with the Supreme Court. And this part is absolutely crucial. He didn't just file a standard civil suit for damages. No, he filed it under Article 32 of the Constitution, arguing that the gas leak violated the citizen's fundamental right to life under Article 21. This was a brilliant move because it elevated the disaster from a basic property or injury dispute into a matter of fundamental constitutional human right.
And guess what? The Supreme Court actually listened.
Chief Justice P.N. Bhagwati delivered this bold rebellion against that outdated British precedent. He stated, "Law has to grow in order to satisfy the needs of the fast-changing society. We in India cannot hold our hands back, and I venture to evolve a new principle of liability." The court basically recognized that they cannot be tied down by a 19th century English law when they were dealing with modern Indian industrial realities. So, the result of this was a brand new standard created by the court, absolute liability. And the definition is entirely airtight. If an enterprise is engaged in a hazardous or inherently dangerous activity and that activity causes harm, they are absolutely liable to compensate for it. Period. It's a non-delegable duty. There are zero exceptions. No act of God, no blaming a third party. It is the ultimate no excuses rule. And this entirely shifted the power dynamic. By tossing out those exceptions, the Supreme Court ensured that powerful corporations could no longer hide behind legal technicalities to avoid paying vulnerable victims. Basically, if an enterprise wants to profit from a dangerous activity, the law now says they must absorb the cost of any accident as an overhead expense. They are forced to internalize the social cost of the hazards they create. To really cement how big of a deal this is, let's look at strict versus absolute liability, side by side. The evolution here is crystal clear. Under the old 1868 strict liability, the law only applied to non-natural use of land, and as we just saw, it was completely riddled with exceptions. But under the 1986 absolute liability, the rule applies to any hazardous enterprise, regardless of land use, and most importantly, it allows absolutely zero exceptions or defenses. None. It was a massive, massive upgrade in protecting the public. So, how did this actually play out in reality? Let's dive into the polluter pays legacy and its real-world impact. Now, you might be wondering, if the factory was so incredibly dangerous, why didn't the court just order it closed forever? Well, the Supreme Court had to balance environmental justice with economic reality. 4,000. That's the number of workers who would have immediately lost their jobs, which would have added to severe social poverty in the area. Because of this, the court allowed a highly regulated, temporary reopening of the plant under 11 incredibly strict safety conditions, which included constant monitoring by expert committees. But listen, they definitely didn't let the company off the hook financially. 3.5 crore rupees, or 35 million rupees, that is the massive deposit the court forced the Shriram enterprise to make just to cover compensation for the victims. Plus, the court established this really groundbreaking rule. The amount of compensation must be correlated to the magnitude and financial capacity of the enterprise. Simply put, the richer the corporation, the higher the penalty. This ensured the payout wasn't just a slap on the wrist, but a true painful deterrent against negligence. And the ripple effects of this single 1986 ruling, they've literally shaped history. In 1991, India passed the Public Liability Insurance Act to ensure immediate relief for victims of hazardous accidents. In 1997, the principles of this liability were applied in the tragic Upar cinema fire to award compensation. And jump all the way to 2020, during the Vizag gas leak, the National Green Tribunal utilized the polluter pays principle, firmly backed by the NGT Act of 2010, which fully incorporated absolute liability. This one single case completely rewired how a nation protects its people. Which leaves us with a really critical question to ponder today. We've seen exactly how the law evolved to close the loopholes of the past. But as technology advances and as industrial complexes grow even larger and inherently more dangerous, is absolute liability going to be enough to protect our future? Or will the law need to grow yet again to satisfy the needs of our fast-changing society? It's definitely something to think about. Thank you so much for joining me for this explainer, and keep questioning the world around you.